Hello, everybody. Okay.
Get it back. And you're controlling it, not me, right?
I just clicked the button. That's all I did.
Okay, yeah, because I can't speed it up or anything or go forward. This is the raw file. This is not the file that I edited.
Okay.
Okay, and then I'm gonna do the second one that goes next. And once I do this, you'll be able to keep up with it.
Yeah, I have no power to zoom forward or anything.
Wait, do I?
I don't ever.
I do. Oh, I do. I have the power. I have the power. I don't have the power to share, but I have the power to speed it up now that he's
Leah
here.
Frank versus Anthony
Perfect.
Frank. For the record, this matter is before the court for a pretrial conference. The same is being conducted via Zoom. Present is Attorney Kirsten Nemec representing the plaintiff, Leah Frank. Ms. Frank is present, presumably, and as well as Anthony Frank. Good morning, everyone.
Yeah.
Good morning, Your Honor.
Court is in receipt of a proposed consent judgment of divorce, which can be entered today if Ms. Nemec, the parties both agree to that the court waive the statutory 6-month waiting period. And the parties are separated. I don't know how long they've been separated, but perhaps we can address that in our testimony. Mr. Frank, are you still there?
We did just lose him, but I see.
It's back now. It left the and
We'll give you a phone number,
Those are
Mr. Frank. You
funny.
seem to be
Oh
in
my
a
gosh.
poor
There it is.
a weak area, so we give you a phone number. You can actually call in and you can appear by audio. Okay? Do you have a piece of paper and a pen?
I have an email.
yeah.
There's going to be some technical difficulties for a few
Yeah, just
minutes. I
the phone number, you
can
can
fast
call this
forward
phone
through
number.
those, but I also want to make sure I convert these files.
Oh no! I mean, the technical difficulties are fun, as we've learned.
9923.
Do you happen to have
Where
a
is
good
this?
connection now with me?
Well, it's
I was
okay.
in a-
You keep seeing
Yeah,
you keep it freezing up.
Yeah, I was in a machine with a
This
metal
is
roof. I thought that might, prohibit the connection.
HYX.
Okay, we'll try this. And if not, you can call that phone number if you keep breaking up. Mr. Frank, what I was explaining is the court can enter the judgment of divorce today that you've approved, provided that you and Ms. Frank agree that we waive the statutory 6-month waiting period and enter the judgment today rather than in August. Under Michigan law, because there's children, there's a 6-month waiting period from the date the divorce complaint was filed. This divorce complaint was filed on February 20th. I believe, yes, February 20th. So 6 months expires August 20th, but this court has the authority to waive that and enter judgment of divorce today. The court would do so if you both agree and you believe it would be in the best interest of your children to finalize things sooner than later. Okay? That's what the court was trying to explain. We haven't catch that, Mr. Frank?
Yeah, I caught that.
All right, Mr. and Mrs. Frank, can you both please raise your right hand and be
Yes.
sworn, please? Do you both solemnly swear or affirm that the testimony you're about to give this matter will be the truth, the whole truth, nothing but the truth, so help you God?
I do.
Mr. Frank?
I do.
Okay, thank you. All right, Ms. Nemec, you can begin with Ms. Frank, please.
Okay, Leah, can you state your name for the record?
Leah John L. Frank.
Okay, and you are the plaintiff in this action for divorce, correct?
Correct.
At the time that you filed your complaint for divorce, had you lived in the state of Michigan for at least 180 days and the county of Monroe for at least 10?
Yes.
You and Mr. Frank were married December 19th, 2015 in Monroe County, correct?
Correct.
And you have 2 children, Abilene, who's 5, and Asher, who's 3.
Correct.
Are you currently pregnant?
No.
And are you stating to this court that there's been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed and there remains no reasonable likelihood of reconciliation?
Correct. Yes.
How long have you and Mr. been living separately?
In September of last year.
Okay, and is there any chance that the 2 of you would reconcile or get back together?
No.
So you signed yesterday a consent judgment of divorce, correct?
Correct.
Okay, and you had time to review that?
Yes.
You understood every part of it?
Yes.
Okay, did you have time to think about it?
Yes.
Did you have time to discuss it with me?
Yes.
Is anyone forcing you or coercing you to enter into the agreement?
No.
Do you think that the provisions in the agreement regarding custody and parenting time of Abilene and Asher are in their best interest?
Yes.
Okay. Do you believe that the property division in the judgment of divorce that you signed yesterday is fair and equitable?
Yes.
You understand that signing it and submitting it to the court yesterday made it binding on you, right?
Correct.
So you can't come back and ask the court to change any of the provisions in that document regarding the division of property.
Correct.
So for example, there's a spousal support awarded in that judgment of divorce. You can't come and ask the court for more
Correct.
because it was non-modifiable, right?
Correct.
You understand that you could have taken this case to trial and the outcome could have been different. It could have been better or worse, correct?
Correct.
But rather than do that, you're asking the judge to take the judgment of divorce that you signed yesterday and also sign it, therefore making it an order of the court.
Correct.
Have you disclosed all of your assets to Mr. Frank?
Yes.
Okay, and are you satisfied with my representation?
Yes.
And my last question for you, as you heard the judge indicate, there is a 6-month statutory waiting period that I believe the judge said would be up in August, and it's obviously not August. Do you wish for the court to waive the balance of that waiting period?
Yes.
And is the reason that you want the court to waive the balance of that waiting period because you think it's in Abilene and Asher's best interest to have some finality and all 4 of you have the ability to move forward?
Yes.
I have nothing further, but Your Honor, it does look like we lost Mr. Frank. Oh, he's back again.
Right, Mr. Frank, were you able to hear your wife's testimony this morning?
I heard everything, but when it came to the August waiting period, and I heard everything before that.
She indicated she is asking the court to waive that. She believes it'd be in the best interest of everyone, including you and the children, to waive the waiting period under the judgment of divorce now so you can move forward.
And on why it's in the best interest. I understand this is ultimately our chosen path and this is where we're going, but I would like just a brief explanation of why it's in the best interest to dissolve it today or August and what the difference is.
Because we've been separated for so long and we're ready to move forward.
And also, Ms. Frank, do you believe that there is any benefit in delay, considering you've indicated on this record that there's no chance of reconciliation?
Correct.
Yeah, Mr. Frank, we're going to give you a phone number. You're breaking up, and we cannot record this. So get a piece of paper and a pen and call in, Mr. Frank.
I
Go
had
back
my
in the
hand
house,
on
get a
it.
piece of paper and a pen. Mr. Frank, we're not going to continue this and breaking up. We need to record these proceedings, and we can't record these proceedings when you're breaking up. So please phone us. Okay?
Okay, I can,
Right,
I'm
We're
gonna
going to
take the
wait
phone
till
number.
Mr. Frank calls in. Of course, not
Go
going to
ahead.
continue with them breaking up every other word. Okay?
I've
So
got,
if you want to text him the phone number, Mr. Frank, call in, please.
Yep, tell me the number. I've got it ready.
Much better. Okay, so we were left off, you indicated you did not hear your wife's testimony regarding the 6-month waiting period. She testified that you've been separated since last fall, and there's no chance of reconciliation. And she believes it to be in the best interest of all parties, herself, you, and the children, to waive the balance waiting period and enter the judgment of divorce today rather than waiting till August. That was her testimony.
Correct.
Right, so sir, can you please state your name and current address for the record?
Current address?
Correct, your name and current address.
Yes, Anthony Frank. Current address is Flat Rock, Michigan.
Thank you. Mr. Frank, did you hear the testimony this morning of your wife, Leah?
I did.
Was her testimony true and accurate to the best of your knowledge?
Yes,
Did you in fact sign your name to this proposed judgment approving the terms and conditions contained therein?
yes,
Do you understand that even though Ms. Nemec is helping facilitate resolution of this matter, she represents your wife Leah and her loyalties lie with Leah? Do you understand that?
I do.
Did you approve this judgment freely and voluntarily?
I did.
The last question, Mr. Frank. Are you asking the court to waive the balance of a 6-month waiting period to enter the judgment of divorce today? Or do you want to delay this till August?
I think August is beneficial actually, for a couple reasons. You know, I mean, we're still going to remain in the same relationship. We're still going to be living separately, but you know, I think that both of us need to, you know, for the children's sake,
I will have to
remain
pay the,
focused.
Stop. Let him speak.
Do you want to talk in a breakout room, Ms. Nemec, with the parties?
I
You're not
can,
gonna get to- If
I
that's
can
what happens, you have to enter some temporary orders regarding child support and some other issues.
yeah, I understand, Your Honor. I will attempt to resolve this issue, but I think it's pretty clear that Ms. Frank's position is that the judgment of divorce should enter today. I don't understand why Mr. Frank disagrees if he's signed both the orders and the judgment of divorce, and it seems like this is only an attempt to delay proceedings, but I will
Right,
attempt.
Mr. Hey, the court would note that the two of you, which is, the court applauds you for being able to co-parent your children. You've agreed to joint legal, joint physical.
Right.
And Mr. Frank, the reality is, unless you think there's a prospect of reconciliation, there appears to be no sense in delaying this. I mean, for the benefit of the children, unless you think that Mrs. Frank's can change her mind and wants to reestablish the marriage relationship, you want to move back in together.
No, I don't see that happen in 6 months. I mean, she ultimately yesterday said that she would love to see that down the road, but I don't know how true that is or not. My sole purpose is saying that I think we need time to not, you know, to focus on the children here and not just say, okay, I'm free, let's start my new life here. Both of us need that time to really be mature and focus on that. And so that little buffer, just a couple more months, would say, okay, listen, yeah, I mean, this is pretty much final, but we're still technically married. I mean, that
makes no sense.
Yeah,
You
just-
know,
well,
You're always
is
gonna
that
be
my right?
parents of
Not,
these children. You're always gonna be parents of
Yeah.
these children. You need to be friends. You need to get along. And obviously, you started on the right direction. You've agreed to co-parent children, which is wonderful. You've agreed to parenting time. You're in the minority where the two of you can work together for the best interest of your children. And you need to be on the same page for the benefit in all the future years. You always need to make sure, Mr.
I
Frank, your
agree.
mom, the kids get a card from mom for Mother's Day. And likewise, mom gets a card for the children for Father's Day. None of that's going to change. It's just a matter of, well, if you think there's a chance of reconciliation. Otherwise, we need to enter some temporary orders regarding child support. I'm sure she needs assistance. If you're separated, we need to address some of these matters, such as not only child support, you've addressed, spousal support. I mean, we need an order entered for spousal support. You're going to start paying spousal support on July 1st. So we need temporary orders and the real estate. Who's gonna pay the house payments between now
I
and
pay all of
whenever in August?
well, it's still you know, in my name. So whether I sign this judgment or not, I'm bound to that until she refinances.
No, you're not bound by it. Until the court signs an order, you're not bound by anything, Mr. Frank.
Well, I mean, not bound, but I mean, that's my credit and my reputation there.
Okay, so are you who's gonna make the payments then? We need to address all these issues. We need a temporary order. If you are refusing to allow authorized court to sign judgment of divorce today, well, first of all, convince the court that it's not in the children's best interest. You may not like it, may not be in your best interest, but what about the children? That's what the court's focusing. So convince this court this morning that it's in the best of the children to delay this matter.
Depending
Yeah,
you know,
my situation.
yeah.
I don't know who's talking here.
Right, Ms. Dimick, do you want to talk with the parties or you just want to maybe court chair for Mr. Frank?
I'm fine, Your Honor. If you'd like to hear Mr. Frank, I obviously will have a response to whatever he has to say.
All right, so Mr. Frank, just tell the court, in your opinion, why it's in the best interest of children to delay things, to delay the inevitable. Normally, there's always some value and finality to all people, all human beings, including children.
There's a what in the finality? I'm sorry, Judge.
There's value to finality, so people know where they're going.
A 3-year-old and
You want to have the
5-year-old.
children to expect that mom and dad are going to get back together. I mean, that's cruel if in fact you think that you're going to try to convince the children that mom and dad are going to get back together.
Yeah, of course, our 3 and 5-year-old hope and wish for that, and we don't plan to have that discussion with them anytime soon. We plan to just love them as we have been. My sole position on whether it happens today or August would be just like a cool off period where, as far as the children's interest, that neither one of us say, okay, I'm free from this divorce. I'm going to go off and, do what I want now. And the freedom aspect overtake the position of this has to be about our children from this point. So it's just basically a buffer to have a cool off period and say, okay, we have a few months here, and
the court's not going to allow you, Mr. Frank, to decide that cooling off buffer period. The reality is, if it's the best interest of children to finalize things. So I'm going to have you talk with Ms. Frank. If in fact you think there's a prospect of reconciling, then that's one thing. But that's only a basis to delay this if you think there's a chance of reconciling. So I'm going to have you talk with Ms. Frank. Maybe she's changed her mind. So we're going to put you in a break room. You can talk with Ms. Frank. And if in fact she agrees that there's a chance of reconciliation, then perhaps the court will delay this. Otherwise, it appears that the court should end the judgment of today's. So we're not holding out false expectations for the children.
Right.
Right.
That's been my heart from the beginning is reconciliation.
Okay. You need to hear from Ms. Frank. So Ms. Frank, we're going to put you in a breakout room. You can talk to your husband and let him know whether or not there's a chance of reconciliation.
Sir, can you hear me? Sir, this is not therapy. This is a divorce hearing. A stipulated divorce hearing. I can't hear anyone or anything.
You can't?
Oh, now I can't. Was I the only one talking?
Yeah. Well, at the moment you were. I was letting you
was
read the hearing.
Yeah, no, so they're going to go to a breakout room. Let me fast forward through that. No, you have the next one. You can do the rest. Yay. Let me stop sharing the screen.
Next one is the
So
one.
he cuts this off and then he starts a new stream because of course he does. Why would it be easy, So of course he does. Let's say stop sharing. Okay.
We call the case of Leah Frank versus Anthony Frank. And Mr. Frank, are you present on audio again?
Yeah.
All right. Ms. Nemec, Mr. Frank, you've had a chance to talk with your wife. Do you believe there's a chance of reconciliation in the next couple months?
Not at this point in the next couple of months, but down the road, who knows with things. I do know that yesterday there was a huge push in the 11th hour to get me to sign papers that I didn't really even get to look over the revision. I mean, I looked them over.
Hold on, stop right there. Stop right there, Mr. Frank. I thought you said you reviewed everything and you understood everything.
I
you signed
did.
Freely and voluntarily. Are you now saying that you did not sign it voluntarily?
No, I did. I'm just telling you that why I have a reasonable level of discomfort is yesterday they messaged me with the revision of this and said you have a half hour to sign it, and I looked it over. I did, and I still signed it.
Court date, Mr. Frank. We had a court date today. Ms. Nemec is trying to be efficient. We had a court date today.
Right, I understand.
Correct, Your Honor. And what actually happened is I changed one sentence in the judgment of divorce that Mr. Frank has had since last week sometime, I believe. And that sentence was changed at his request. We redefined 1 week of vacation from 7 days to 5 days. There was one sentence change. I did advise that it needed to be signed within a half an hour in order for me to get it to the court in time for the court to have access to it before this morning.
All right, so Mr. Frank, are you asking for an adjournment so you can consult and retain an attorney? Is that correct?
I personally would like that, but I know that Leah is just ready to be done with
All
it.
right, all right, the court, how much time do you need to hire an attorney? Can you do that in 2 weeks?
Well,
Anthony.
listen, let me finish the sentence. I don't think an adjournment's going to change a whole lot. I just have to say that Leah's, it's not even about the relationship or salvaging it, but Leah's.
Mr. Frank, do you want to talk to an attorney? I've got the other parties waiting. Again, I understand you want to talk. And again, the reality is, if in fact you don't want the court to enter this judgment today, do you want to talk to an attorney? The court will adjourn this, give you a chance to talk to an
Yes or
attorney.
no?
Mr. Frank?
I'm sorry. Yeah, I heard her talking too. I'm sorry. Yeah.
All right, court's going to adjourn this matter. Mr.
gosh.
Frank,
No,
contact an
I don't
attorney
think-
forthwith. We're not going to play games, Mr. Frank. The court is
I'm
a
not.
busy
I'm
docket.
actually.
Ms. Nimick is busy, so we're going to give you another date in about
Anthony,
would, 2
Michael.
or 3 weeks be
Yeah, I'm
sufficient?
listening. Listen, let's get it done. I'm telling you, I'm not comfortable with this, but I don't think it's going
Right,
to
the
change
court-
much.
Mr. Frank, stop right there. We're not going to proceed any further this morning. You're saying you're not comfortable with this? Of course, not proceed with
No,
it.
Judge,
And through a
Judge,
judgment, you're not comfortable with it. So stop
Let-
talking,
let
Mr.
me-
Frank. We'll
let me-
give you dates. Ms. Nimick, what day in July are you available on a Friday?
Miss
Your
Neiman, can we
Honor.
please?
Miss Cindy?
Your Honor.
Hold on.
May I? Yeah.
No, Mr. Frank, I got other matters waiting. There's, we don't
Let-
have time to
let-
talk. You can talk with
let-
an attorney about these matters.
No,
I'm
there's
done.
no attorney. Let's just get it over
Miss
with.
Nimick, hold on. Mr. Frank, do not interrupt, please. We're looking at some dates in July.
The earliest
don't wanna-
we have available in July, Your Honor, it's July 19th.
Miss
Your Honor,
Neiman,
I don't want to do this to
Yeah,
her. I don't want to do this.
Do anything about what he's saying on the record, Leah, okay?
I don't want to do this to her. I want to finalize it. I'll
July
just do
19th
it.
at 9 o'clock. Miss Nimick, you available July 19th at 9 a.m.?
I am, Your Honor.
All right, this matter is adjourned to July 19th, 9 a.m. Mr. Frank, please consult an attorney so we can move forward with this matter. Talk to an attorney and find
Your
out what your
Honor.
options are. We'll mail you notice
Your
at
Honor.
the Huron River Drive address, and this matter is concluded. We're adjourned. Have a good rest of the day. You can zoom out.
Your Honor.
You heard the man. Zoom out.
You hear the whole thing, but like somewhere midway through it, the video part starts to freeze and they keep talking. So you can tell how it ends and like what happens by just continuing to listen to it.
Hi, Leah.
Hi.
How are you, dear?
Fine.
Good.
No, 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 no.
I got Asher's T-ball pictures here.
Good.
He called her dear. She's so uncomfy.
For the record, this matter is before the court for entry of a proposed consent judgment of divorce. This hearing is being conducted via Zoom. Attorney Kirsten Nemick is present representing the plaintiff Leah Frank. Ms. Frank is present, as is the defendant Anthony Frank. Good afternoon, everyone.
Good afternoon, Your Honor.
Afternoon.
Parties were before the court on May 31st for a pretrial conference as well as entry of this judgment. The court had a conversation about the waiver of the 6-month statutory waiting period. Ms. Frank indicated there was no chance of reconciliation and she was asking the court to do so. She stated it was in the best interest of the children to finalize things sooner than later. Mr. Frank was hesitant and which the court could still have granted, but Mr. Frank seemed to suggest he was being rushed into enter this judgment. So the court adjourned the matter to July 19th so Mr. Frank could talk to an attorney. My understanding is Mr. Frank is joining this request to have a matter brought before the court this afternoon. Is that correct, Mr. Frank?
Yes.
Okay. Have you had a chance to talk to an attorney?
I'm on the Asher. No.
No, I didn't need to. I'm settled with the matter.
Okay. So what do you want the court to do this afternoon?
We're going to proceed and finalize this.
Okay. So let's pick up where we left off. There's a statutory 6-month waiting period. It's 6 months begins to run the date that the divorce complaint was filed. The divorce complaint was filed by Leah on February 20th. So it expires August 20th. This court has the authority to shorten that and waive that. And generally it's in the best interest of the parties and children to move forward unless you really think there's a chance of reconciliation. Or there's a reason like Ms. Frank needs the health insurance through your employer and has a medical procedure coming up. So Mrs. Frank is requesting the court, rather than sit on this till August 20th, she's asked the court to enter the judgment of divorce without delay. Are you today asking the same thing?
I am.
Mr. Frank, let me ask, obviously Ms. Frank is still asking the same. Mr. Frank, are you asking the court to waive the balance of waiting period and enter the judgment of divorce today?
I'm agreeing to it. Yes.
Okay. Again, you seem to suggest you're being rushed into things. You've had now another week to review this judgment, all
No.
the terms and conditions. If you
No,
we've not finalized things, if you want to change your mind, you can change your mind today and say, I want to renegotiate some of these terms. You understand
No,
that?
I'm okay. I'm agreeing with it. I'm not the one that needs to push it till right now. I could have waited till August, but I'm agreeing with it for Leah's benefit. I'm good with it.
So you believe there's some value in simply finalizing things so you can move on with your life?
Yes, I understand that. Yeah.
All right. Again, this court is of the opinion that perhaps Mr. Frank is holding out hope for reconciliation. Ms. Frank was pretty adamant that there was no chance for reconciliation. The court is of the opinion that most generally, unless there's a more valid reason, that the parties are the children are best served by finalizing things sooner than later. As a court recall, we did take all the proof. The court established jurisdiction and everything. Is that correct, Ms. Nemec?
It is. And in addition, if it helps the court with regard to waiver of the waiting period, Ms. Frank does have an active PPO against Mr. Frank currently. And there was a domestic violence charge that was adjudicated in February for which Ms. Frank was the victim. This is another reason.
That matter. Is Mr. Frank on probation?
No,
Okay.
it's really irrelevant. She just wanted to bring it up.
Okay. Is that still pending?
No,
it was adjudicated.
It was adjudicated in February. I'm not aware of what the sentence was, but it was a domestic violence charge, originally charged as a domestic violence second offense. It was pled down to a domestic violence first. Mr. Frank was the defendant. Ms. Frank was the victim.
Okay. So
Which
that
has no
PPO is still
bearing.
in-
Which
I'm sorry,
has
Mr.
zero.
Frank?
It has zero bearing on whether we wait till now to August, but she just wanted to bring that up. Maybe she'll
Right.
post it on TikTok again.
Well, is that PPO still in full force and effect?
It is, Your Honor.
Okay. And that's a separate issue from this judgment of divorce. You understand that, Mr. Frank?
I understand it. That's why I don't know why she's bringing it up.
Okay. All right.
Either to you probably, but she just decided she needed to.
Well, people should get off social media. There's more problems caused by social media and TikTok and all that other garbage.
I don't have that. I was made aware of it.
All right. So, Mr. Frank, do you have any questions for the court?
No,
Once again, do you want to talk to an attorney?
no,
And you have no objection to the court signing this judgment of divorce today. Is that correct?
no.
All right. Ms. Nemec, is there anything further from your client's standpoint?
No, nothing further. Thank you.
The problem, the reason, Mr. Frank, Ms. Nemec probably raised that issue is because of the fact it gives you perhaps more reason why the parties should finalize things and move on with their lives. So there's no one's playing games here, trying to cast you in a bad light on social media. Hopefully there's no need for anyone posting this on social media. It's all matter of public record. In any event, based upon the testimony that was provided back on May 31st, 2024, as well as complaint filed in this case, the court finds again that jurisdiction's been established.
And everywhere else.
And the court further finds that there has been a breakdown in the marriage relationship to the extent that the objects of matrimony have been destroyed. There's no reasonable chance of reconciliation. The court will in fact act without delay and waive the balance of 6-month waiting period. Enter the judgment of divorce today. According to ordered by this court that the marriage between the parties be and is thereby dissolved and judgment shall enter granting a divorce from bonds of matrimony. The court will sign the judgment Ms. Nemec will mail you a copy of this judgment for your records, Mr. Frank. And with this action today, the court will cancel and vacate the pretrial conference scheduled for July 19th at 9 o'clock. No need for that, okay?
Yeah. When did the actual payment arrangements and things go into effect? So July 1st then, or when would that?
August 1st. The Uniform Strasbourg order says August 1st.
Okay.
Is that correct, Ms. Nemec?
I believe so. I don't recall off the top of my head. I know that we had a uniform spousal support order and a uniform child support order. My recollection is that child support is actually reserved for the first year because in lieu of child support, he was going to pay non-modifiable spousal support in an amount around $3,500. And then child support would commence August 1st of next year, when the
Okay.
spousal support would then modify. He would then be paying child support in the amount of $1,100 and spousal support in the amount of $1,100 for the next 18 months.
Yeah, that's all agreeable. From now till August 1st, though, I don't know if we can really, I don't think we can write this in, but so far we're still on a joint account that most of these monies are going to come out of to pay these bills, to pay the home, to pay the car. But from now to August 1st, I'm planning on paying this just as I have been, but there can't be any additional spending as there has been in this last month. And there has been, Ms. Nemec, so don't shake your head. You don't know about this. There has been additional spending and it has been unnecessary. And I'm footing the bill and I can't keep doing that. Beyond paying the home, the car, the insurance, there's Cedar Point trips now. There's well, Ms. Nemec, I just paid you and I don't want to pay you, but guess what? It came out of the account. So I don't want to, I want that to freeze though. I want to pay the bills. I want to take care of the kids, but I don't want any more spending.
Your Honor, may I interject? There's a status quo in place that stays in place until the orders that were signed supplant those. The orders don't begin August 1st. They begin, I believe, July 1st.
I believe it's July.
Yes, the dollar amount that he will be paying, as I previously stated, child support is reserved for 1 year. We have a uniform child support order that will enter August 1st of 2025. He will be paying spousal support in a non-modifiable amount, and I'm trying to find it here quickly. He will be paying spousal support commencing July 1st, 2024 in the amount of $3,534.39 per month for 12 months. It was going to be paid directly no later than the first day of each month. And then commencing August 1st, 2025, he would pay spousal support in the amount of $1,100 per month for the next 18 months. Also commencing August 1st, 2025, he would begin to pay child support in the amount of $1,100 per month.
Yep. So now we know those.
I just want to make sure that Mr. Frank understands that
I do.
spousal support does not commence August 1st. It commences July 1st of 2024. And until that time, the status quo order remains in effect.
Okay, so things that are above and beyond status quo that I'm not agreeing to, but that are just coming out of the account. And since it's my account, when it's depleted, I replenish it. I don't anticipate Leah just going on a spending spree, but at the same time, there's been several things that I have not approved that keep coming out of the account. And it's not, if it was, running to Walgreens and getting the kids medicine for $50, that's one thing. But right now in this time, we don't need to be taking $500 Cedar Point trips. I mean, it's just not the time.
Well, Mr. Frank, Cedar Point tickets would not be part of status quo. Those are over and above. So
I know
Ms.
they
Frank
are.
is purchasing those out of a joint account. She needs to restore those funds to that joint account. Ms. Nemec, that's the court's thought.
That my point is, I'm not trying to even get her to restore that. I'm trying to say, let's not do anymore. Okay. That's all I'm trying to say is I believe she understands that, but I just want to say,
I understand.
Yeah,
I
why don't
believe
Can you
you
repeat
close out?
yourself, Leah, because you were inaudible.
I said I do understand what he's saying, and I agree with that. And anything above status quo, I agree.
Okay.
the problem is
I wasn't asked, consulted, it just came out of the account, so you just can't do that going forward, Leah, at all.
Mr.
agree.
Frank, you just heard Ms. Frank say that she understands and she agrees. So I believe that this matter is settled.
It was also understood and agreed to 2 months ago when I said stop the spending, and guess what? It's happened several times since, so.
Should
I
not
just
that
want-
joint account now be closed out?
It would be closed out once the spousal support starts being paid in July. We needed to get through the rest of this month. Ms. Leah is, or I'm sorry, Ms. Frank is not employed outside of the home. Spousal support is going to be her only form of income for right now. While she navigates this new change in circumstance, Mr. Frank has repeatedly expressed that he wishes for her to be able to stay home with the minor children and not have to work outside of the home. But now,
Yes, that
So the
remains,
question is correct. Hold on. The spousal support starts on July 1st. Well, why can't Mr. Frank pay it? Why can't he close out that joint account so we don't have more withdrawals and expenses being paid out of the joint account? And we don't have to then argue about whether or not they're status quo.
because then she would have
that's it.
no access to funds for the remainder of the month of June. It's
Why
June.
can't he pay? Well, the only obligation he's got is to pay her the spousal support for July, correct?
Beginning in July, if he would like to make that payment today, the $3,500
that's not how that,
dollars.
that's not how that works, Ms. Nemec. The 3,549 is the total sum. I paid the bills, and then the bills are deducted from that 3,549, and she gets the remainder, which we haven't figured yet, but it's right around $1,000 a
The
month.
way it does not work, Mr. Frank, is that you be enabled to give Ms. Frank absolutely nothing for the month of June. The
Right,
reason
no, that's not what I want.
this
This
was
is,
part of a negotiated agreement that came from a mediation. And now what I hear Mr. Frank trying to do is change the terms of the agreement that
no,
was
you're right.
negotiated
The
as
terms
a
were
result of
changed.
mediation in which he signed his name.
So one thing that wasn't addressed is spending up above and beyond the status quo. And I'm
And she
telling you,
already stated to you, Mr. Frank, that she heard you and she agreed.
and I
So
stated to
again,
you that she heard me 3 months ago and agreed, and it's still not happening.
Again, the matter has been addressed. She acknowledged what you were saying on a record before this court, stated she understood, and she agrees not to spend beyond the status quo.
I'm not asking for repayment either. I don't want that. I want to just make sure if I see something come out from Myers or Walmart or something that's a grocery, I'm not mad at that. But unnecessary spending. That's all I'm talking about, Leah. That's really it. And
Your point has been made, sir.
since you've agreed, I'm good
Okay.
with that.
And Ms. Frank has indicated she understands that and she does not disagree with you. In fact, she agrees with you, Mr. Frank.
Okay, we're good then.
All right, so again, Ms. Nemec, again, I'm looking at the judgment, page 5, says spousal support. In answer to Mr. Frank's question, Mr. Frank is ordered to pay child spousal support commencing July 1st, 2024 in the amount of $3,534.39 for 12 months. And then commencing August 1st, 2025, the spousal support should be reduced to $1,100 for 18 months, correct?
That is correct.
And you've attached to the judgment a uniform spousal support order.
There should be two, I believe.
Okay, maybe that's where my confusion. Of course, there's a uniform child support order, and that, of course, provides child support will commence August 1st, 2025. There's a uniform spouse support order indicating
That comes up.
spouse support should be payable in the amount of $1,100 August 1st, 2025. I want to make sure that second.
We did have a hard time, Your Honor, getting signatures electronically on the 30th, and they had to be sent multiple times. And unfortunately, I don't have an executed copy in my file because I believe they all came over to the courthouse. I'm trying to find the electronic copy. There are so many copies of it because of the technological issue or the technical issues we were having that day.
Okay.
Is it
does
not
appear we need a
attached to what the
second.
court has received?
It appears we need a second uniform spouse support order, the one that indicates spouse support to be paid for the judgment in the amount of $3,534.39.
Your Honor, I'm sorry. It's because that first amount is to be direct paid. I'm sorry. I stated that multiple times. So that was not through front of the court. It was to be paid directly.
Thank you. Of course, that's correct. This payment should be paid, made directly no later than the first of each month.
Correct.
So again, Mr. Frank, in answer to your original question, I was just looking, there's a number of documents here. Your obligation under this term of this judgment, you pay spouse support and the amount of $3,534.39 for 12 months. You pay that directly to Ms. Frank commencing July 1st. And then,
Your Honor, Your
then
Honor,
it'll come out of your paycheck commencing August 1st, 2025, when it goes down to $1,100 per month. And its child support is reserved until August 1st, 2025.
right.
So we're all on the same page on that, correct?
I just so you know, the amounts are perfect, yes, but the way that the both things are structured, you know, the dollar amount of 35, 39, whatever it happens to be, is that total amount she gets for the month. And then all the bills come out of the account. That's the joint account that you see. So they come out automatically. You know, her car payment, all of it comes out. And whatever's left out of that 35.49 is what remains to her for whatever she needs, groceries, whatever, that's her business. So just so you know, the way it's structured is she doesn't just get a check for 35.49 at the beginning of the month and do whatever. So just so we're clear on that. And the second thing is I'm self-employed. So at the time where it's going to go through the front of the court in 2025, I'll have to work that out, how I get them that draw every month, if I take it in, or if it's, I think they do automatic deduction as well.
You notice how he's not asking the judge anything? He is telling the judge everything.
Not if you're self-employed, you pay that directly in front of the court.
Starting August 1st, 2025.
Correct.
I'm sure they'll be in touch before that point.
Okay, any other questions, Mr. Frank?
No.
Anything further, Ms. Nemick or Ms. Frank?
No, no.
I have nothing further. Thank you.
All right. Hopefully the parties will not be back in court soon. Ms. Frank understands and agrees with Mr. Frank's assessment of expenses being paid out of that account, which are not in the ordinary course of business. And with that, the court will sign the judgment and the uniform support orders, and that will conclude this hearing. Again, the pretrial conference of July 19th is vacated. All right, good luck, Mr. and Mrs. Frank. Now you can zoom out. Have a good rest of the afternoon.
Thank you, Your Honor.
For the record, this matter is before the court on the petitioner Leah Frank's motion to modify a personal protection order entered by this court on December 22nd, 2023. This hearing is being conducted via Zoom. Ma'am, you are Leah Frank, is that correct?
Yes, I am.
And sir, you are Anthony Frank?
Correct.
Right. Ms. Frank, you're asking the court to modify a personal protection order.
I am.
You allege that Anthony continues to push boundaries, play games with me in regard to our divorce and children, cause repeatedly tracks for Yukon. Have you filed a complaint for divorce?
We just finalized our divorce last week.
Finalized it?
Yes.
Last week.
Okay. The issues that you raised should be addressed in the divorce action. The court has a lot more authority, a lot more leeway to grant relief in a divorce action than a personal protection order. PPO just protects your person. If in fact he's tracking your car, if there's a problem with the exchanges of the minor child or children, then you file a motion in there. They do the exchanges at the police department, for example. You can have a third party and do the exchanges, things of that nature. But I'm not sure exactly what you're requesting that I do, how you suggest I modify the personal protection order. The personal protection order that exists simply prohibits Mr. Frank from threatening you or assaulting you or interfering with your employment.
Any further communication other than speaking about to me in regards to our children, and then when we're at events in regards to our children, if he could not come up to me and speak to me, that would be wonderful. Or make comments.
You need to file a motion in the family court case. The court will order generally that the parties communicate only by app close, only regarding the child. So there'd be no communication. I can address that in the divorce action. The court has a much broader authority in the divorce action than this PPO.
We do communicate through AppClose, and I have multiple communication in regards to me saying, leave me alone and please stop. And he continues.
Okay,
So
communication should only be regarding the children. So what you want
Right.
to do is file a motion for to show cause and ask the court to hold him in contempt for violating that provision in the judgment divorce. If he's communicating about things not involving the children, the court can start contempt proceedings.
in the AppClose, he's continuing to communicate things that are not in regards to our children. And I've asked him repeatedly to stop. And I've also asked him not to speak to the children in regards to adult matters, and he continues to do that as well.
Okay. Again, this person protection only relates to you, to your person. It doesn't relate to property, to the children. So the court's suggestion is that you file a motion in the divorce case. For example, it's called the motion for to show cause, alleging that he is not complying with the terms of the judgment. He's communicating with me via AppClose, but things that have nothing to do with the children. And if you want other restrictions put in place, the court can address that. The court has much broader authority in that family court divorce action than they do in this PPO. This PPO just protects your person. If he's threatening you or assaulting you, that's one thing. But if it has to do with the children, communicating about other things, that's to be addressed in that divorce action.
Your Honor, I have a question for you.
Go ahead, Mr. Frank.
In the divorce, there is no stipulation saying there's only strictly communication for the kids. So I don't. If I saw something like that and it said you just cannot communicate with her unless it's strictly about the children, I realize that is generally what the nature of our relationship needs to be now. But as far as like a black and white line that I violated, I don't think that's something written into the divorce proceedings,
If requested by Ms. Frank, the court would do so. You're divorced now. So you move on with your life. The only time you have to talk with Ms. Frank has something to do with your children.
Right. If we did go to that hearing, for example, like right now, both of our kids have things we signed them up for, commitments, T-ball, this, that. Would that be something we would address as far as like, okay, there's a T-ball schedule. I'm coming from Flat Rock all the way down to see T-ball, but it's Leah's day. Can she just say, well, I'm not taking them on my days? It's going to be cause that we need to just respect each other and communicate and do these kind of things. And my only reservation with the AppClose, I respect what Leah is asking for. I know that there's been things said that are adult matters that are not about the children that needs to end right now, completely, period. It does. She's correct, and it needs to be done with. So when we're talking about just the children, their well-being, to try to nurture them and make them whole, and when they do see us exchange or communicate, it needs to be a healthy, wholesome situation. And we've been to 6 or 7 T-ball games and not a word has been said negatively in that interaction. So what I'm saying is we just need to work and respect each other as far as like even the schedules. If I drive 20 minutes from Flat Rock because there's a game scheduled and she says, well, I'm not taking them today. We have to work better than that together,
Court could not agree more. But again, this motion to modify the PPO is misplaced. Ms. Frank, any issues that you want to address should be addressed in the divorce case. So file a motion in that case or to show cause if Mr. Frank is communicating with you. Again, I don't have that divorce case for me. I don't see the judgment, but if in fact there's no provision that it be only that AppClose be only regarding the children, that's where it should be. But if it doesn't say that specifically, the court would put that in black and white without question. So Mr. Frank, just move on with life. Communication should be only regarding the children, and it should be effective communication. If in fact one of the children's ball game is canceled or they're not going to be there, it's just it makes sense that you notify the other parent.
Yeah, I think that's where we could actually help each other out a lot and pick up the slack. If she can't make it, she's got 4 other kids to balance besides these 2. If she can't make it, these 2 are my priority. I don't want to miss anything of theirs. So I can pick up the slack on her days. I really want to be there to do that.
do you guys think that he's being genuine in his humility that he's showing at the moment, or do you think that he's playing the judge?
Okay. Right, Ms. Frank, do you have any other questions for the court?
I do. So just I guess just to clarify, the PPO is only in regards to me personally,
Safety.
and my
Correct. Your
safety.
safety.
Under this PPO, he's basically solely just not allowed to threaten me or to
Touch
cause.
you.
Yeah, that's a concern
Or
for me,
interfere
Your
with your
Honor.
employment. Hold on, Mr. Frank. Hold on. Let her finish. It
Yeah, I'm
prohibits him
sorry.
from threatening you, touching you without your permission, or interfering with your employment.
And that's it. So he can show up anywhere I am other than my employment. If it's at any other game of any one of my children's or any other school event or anything, he can track me on my Yukon and follow me.
Hold
These
on,
are all-
hold on. Stop there. He can show up he can run into you at Meyer. He can show up at a ball game. Yes. Now tracking you on Yukon. No, he can't do that. And if he's doing that, contact and make a police report. Maybe there's a criminal violation. I don't know that. I'm not a criminal judge. But make a police report if he's doing that. And if he continues to do that, you can petition the court and I can order him not to do that. If he does, I can hold him in contempt, put him in jail.
Okay, so you're telling me that I have to go and make a modification to our divorce in order to make the things that I'm asking and requesting.
Correct.
Okay.
Correct. The court has much more latitude to grant the kind of relief you're seeking in the divorce case, not this PPO.
Okay.
You know, Leah, you're not asking a lot. This is not
Okay.
hard.
Okay, please work together, and any communication should be on EPO should be only involving the children and their activities, Mr. Frank.
I understand,
So
Your
with
Honor.
that, the court went into order denying the motion to modify. Again, this PPO continues and does not expire until December of 2024.
Understand.
All right, so obviously life is too short. There's enough challenges in life. Work together and make life easier, good for both of you and the children. That's what the court would ask you to do.
Thank you, sir.
All right,
Thank you.
that will conclude this matter. The court will enter order. You both know the copy of this order.
Thank
You
you.
can zoom out.
Zoom out. Zoom out. Be safe, be well, sleep sweet, and much love.